having a difficulty exiting the court. There we go. Okay. Yes, you've got 5 minutes, Mr. Graff. Go right ahead.
Perfect. Thank you, Your Honor. The issue at the heart of both of these appeals, which are traveling together, is the process for determining breach of contract, confession of judgment, and entitlement to fees in an insurance breach of contract matter where the defendant and the insurance company invokes and pays an appraisal award.
Post lawsuit.
Post lawsuit, correct, and that is the case in this case, Your Honor. Is that, and I won't go into extensive detail. Certainly, my brief does, but briefly, there was a water loss. There was a dispute over the amount of benefits due under that loss that was communicated pre-suit. There was a suit filed by plaintiff alleging that further benefits were due. There was an answer by defendant saying that no further benefits were due, while also reserving the right to invoke appraisal. Appraisal was ultimately invoked and occurred. And when the appraisal concluded, additional benefits were due to plaintiff, and they were paid. Now, case law in Florida is clear, and under the cases cited throughout the briefs in this matter, but I'll briefly list a few of them: Clifton, Goff, Beverly, Hill, that in situations where that appraisal award is paid and there is no rush to the courthouse defense pled and proven, and I'll get to that in a moment, that is an automatic confession of judgment. And the quote from the case.
Client need to move the court for a determination of the confession?
I believe that my client would have needed to have a hearing either on a summary judgment basis or trial. And ultimately, this is where I believe the confusion occurred in this matter, Your Honor, on the confession of judgment issue. And the reason that is because every case that I'm aware of that I've researched on this deals with the matter through a summary judgment basis, where the facts weren't contested. There were no contested facts. There was a record developed. There was summary judgment evidence presented to the court, and what is
the factual determination there?
The factual determination that needed to be had here, Your Honor, is because defendant was refusing to pay any attorney's fees or to even acknowledge entitlement to attorney's fees. The factual determination that has to occur is whether there was a rush to the courthouse, which is the sole defense.
Let's back up for a minute.
Yes.
After the insurer paid the appraisal award, they submitted a proposed order dismissing the case, reserving jurisdiction to determine entitlement to fees.
Correct. And the plaintiff did not agree to that because that is not the method that the statutes and the case law say is to occur here. So going back to the statute itself says in the final judgment, entitlement to fees is to be.
I think we can kind of, some of this is dancing around the fact that they really wanted, the insurance company really wanted either a dismissal or a judgment in their favor because they had a proposal for settlement, which I know is bleeding over into the next case. But that's kind of the white elephant in the room here, right?
But wait, the timing on the proposal for settlement was that it wasn't filed until after the insurer submitted the proposed dismissal order. Isn't that right?
Correct.
So what the insurer seemed to want, at least under one view of it, is to get the case over with. And they weren't really fighting with you about being able to have a determination of entitlement. They were proposing that in the order of dismissal. And your client didn't want that. Help me understand where I'm wrong here. Because
you're not wrong, Your Honor, but that's.
Oh, wait, I'm not finished.
I'm sorry.
Here's my question. If your client had agreed to the order of dismissal with a reservation for entitlement, what would have stopped your client from then asking the court to make a determination of confession as part of the entitlement? Why wouldn't that have been the appropriate vehicle?
Because entitlement is to be determined by the court in the final judgment. Prior to the case being dismissed.
Courts reserve jurisdiction on entitlement all the time. Is this a special case?
Yes, Your Honor, it is. And the case law says that. So Palma makes clear that, and this is a 1993 Supreme Court case, that entitlement to fees is part and part of the breach of contract action and is to be determined and dealt with in the final judgment.
You're concerned with a whipsaw. That if it gets dismissed without it being baked into the judgment itself, that you will have inadvertently lost the right to seek it because of the Palma holding.
100%, and not just because of Palma. This is carried on by this court in Clifton, Goff, Beverly Hill. All of those cases were reversed on a summary judgment basis, where the court did what Your Honor, Judge LaBritte, you're suggesting right now, which is find in favor of the insurance company because they paid the appraisal award, and then deal with any kind of request for fees afterwards. That's not appropriate. The final judgment has to find that there was a confession of judgment, that there's an entitlement to fees as a part of this process.
So
With the insurance company,
after the insurer filed its suggested dismissal, and then it filed a proposal for settlement, your client didn't do anything. You could for several months, and then ultimately an insurer filed the summary judgment motion. Where might your client have filed a motion, a cross motion for summary judgment, or some other affirmative request to make a determination that it was entitled to fees pursuant to what you say is the confession?
Your Honor, what was argued, well, first of all, there was request for discovery out there. With respect to having that hearing's not appropriate until plaintiff is aware of what defendant's basis is for refusing to pay the fees. So there, and that's the confession of judgment part, and the rush to the courthouse. I haven't quite gotten there yet. But that is the part that's being ignored here. There's only one basis that the insurance company can plead and prove and argue to not pay attorney's fees in this situation, and that is a rush to the courthouse defense. It's talked about in a number of second district cases, but essentially what those cases say is that if the insurance company was unaware of a dispute, they didn't have the opportunity pre-suit to invoke appraisal, and therefore there can't be any.
To cut you to the chase, right? I follow your argument. You're saying the rationale of Goldman doesn't apply because there was no rush to the courthouse. And the reason there was no rush to the courthouse, tell me where I'm wrong, is that your client pled in the complaint that there had been a notice given before suit that your client was owed proceeds, and the insurer ignored it, didn't respond favorably, filed suit, they went to appraisal. That's essentially the facts here, right?
Those are the facts in a nutshell. Yes, Your Honor. And I'm trying not to cut you off. I don't mean to speak over you. Yes, Your Honor. And so in preparing for a summary judgment hearing, I believe plaintiff has the right to and needs to know what defendant's basis is for asserting that there is no entitlement to fees. And so that was discussed at the hearing.
As a practical matter, and this is where I have a problem, I'm not sure that you have a good record that the defendant was saying there was no basis for fees. I think that you may have had in barring from Cool Hand Luke, a failure to communicate. But the insurer's perspective was you dismiss and will litigate entitlement.
And that's fine with that, Your Honor. Just
move for fees, do something to set up the fee claim, and we'll oppose it or address it however. But your client kind of laid in wait.
Your Honor, there wasn't a failure to communicate. There were discovery response or requests pending, and there was a request to defendant for depositions to address the remaining issues in this case, which could only be rushed to the courthouse. The fact that defendant first filed a motion for, and by the way, Your Honor, I would disagree with the assertion that defendant never contested the right to attorney's fees. Defendant filed a motion for summary judgment asking for judgment in its favor on the breach of contract action, which would prevent any basis for fees being.
But in the end, the judgment is more neutral than that, and your client never filed a motion for fees or for determination of confession.
My client filed an appeal because my client had to. So the final judgment was entered in defendant's favor.
Did your client ever ask this court to relinquish jurisdiction to go back on the fee claim?
Pardon me, Your Honor?
Did your client ever seek a relinquishment of jurisdiction to go back and deal with the fee claim?
No, Your Honor, because if my client lost the case, which is what the current status of the record is, there's no basis for my client to seek fees. My client only gets 627, 428 fees to the extent that it gets a judgment in its favor, or that or a confession occurs. Judge Atkinson, I'm sorry.
No, I was finishing your thoughts incorrectly, but go ahead.
Okay, so in plaintiff's reckoning of this case, there was a judgment entered against it. Now the basis for 627-428, the only basis for fees, is cut off. The path to deal with that is to file an appeal, ask this court to reverse that final judgment in FedNat's favor, which found that FedNat was the prevailing party because it paid an appraisal that it invokes, and then have the correct factual determination that has to occur here, which is what factual basis FedNat has for asserting that it does not owe attorney's fees. And if it can't prove that up, then to enter a final judgment in plaintiff's favor, as Beverly, Goff, Clifton Hill, all these cases dictate should occur. And at that point, then there's a final judgment and we have an amount fee or an amount hearing afterwards. But that judgment has to not only pursuant to those second district cases, but also pursuant to Palma and pursuant to 627-428 fee, that judgment itself has to have an entitlement to fees in plaintiff's favor. And I do want to go back to a point that I think is important. At no point did defendant say, we agree that you guys are entitled to fees, or we don't contest your fees. They filed a motion for summary judgment citing a rush to the courthouse case. They cited Goldman, which is this
kind of touches upon a lot of what we're all struggling with here, which is that there is no rule of civil procedure that governs appraisal process and entry of judgment upon, I should say that there is an other appraisal context, not in this kind, not when it comes about from an insurance policy. There's no rule of procedure that tells you what to do. So how does one frame the issues and procedurally litigate the issue of a rush to the courthouse defense? Because it wouldn't necessarily arise in the opening salvo of the breach of contract, of a typical breach of contract action, putting aside what Palma says this kind of breach of contract action is, right?
Correct, Your Honor. And I think the way that it's framed is by the fact that it was brought up in the motion for summary judgment, partial summary judgment by defendant.
Right. And you wouldn't have a jury determine that either, or would you? I've never heard of it being done, but maybe it has. I don't know.
I haven't heard of it being done either, Your Honor. But this was one of the things that I think the trial court struggled with, and certainly plaintiff did its best to be candid during the final hearing about it, which is I was unable to find any case law, and plaintiff was unable to find any case law that said exactly this is how it's done. But in my reckoning of jury trial situations, there's two ways to deal with factual issues. The first way to deal with the factual issue is if there is no factual issue, you have a summary judgment hearing, there's uncontested summary judgment evidence, the court looks at it, applies a law, and there's a result. The second way in a jury situation is through a jury trial. And that was the argument.
What would that look like? You would have like an interrogatory verdict that says, was there a rush to the courthouse? I mean, what? Well, it would be them to decide.
Was defendant aware of, and did they have the power to resolve the dispute prior to suit being filed? And that's really what Goldman talks about. So briefly, the Goldman issue.
And help me out, because usually we have juries decide. And you probably don't have a good answer to this, because the reason we're here is to some degree how some of the case law has construed these kind of these actions. But usually we think of jury verdicts as being tethered to elements of a legal claim in civil cases, elements of a legal claim, or elements of a defense.
And this would be
rush to the courthouse. Really, in a breach of contract action, you've got very defined elements of what those are, and you have a number of affirmative defenses that are available to a breach of contract action. Rush to the courthouse is not a recognized legal affirmative defense to a breach of contract action. It's its own kind of separate defense to the sept of issues that comes out of these kinds of contract issues. Do you see what I'm saying?
I absolutely understand that, Your Honor, and you're touching, and it feels almost gratifying, touching on one of the frustrating parts of litigating this from a plaintiff's point of view. And the only thing I can say is that recognizing it as a defense to a confession of judgment to a breach of contract and I understand that from the court's reaction, there's two levels there. But regardless, however, that whether it's by the court or by jury, either through summary judgment or a bench trial or a jury trial, which are really the only three options. What the case law is clear on, blissfully at least, is that it has to occur pre-judgment. And that was what plaintiff was trying to make the point to the court, was asking the court to first of all require discovery to be done so that these issues could be addressed, once again, either through a motion for summary judgment or a brief jury trial. And
So
what,
is it possible that jury instructions could get you there? I mean, if there was a jury trial, I mean, in other words, is it possible to tether it back to the cause of action for breach of contract? And the instructions being, well, here's the law that they're contract. What are they contracted to do? They're contracted to pay covered claims. If they, if after suit under the case law they paid, that is you need to find that out, jury, because that means that they did breach the contract because they didn't pay when they should have.
correct. I believe there is a way to do it through jury
And
instruction.
then the defense, there's an instruction that says, but however, I mean, yes, then I'm sympathetic with Judge Lucas's curiosity about how that part would fit into a jury instruction. But
Well, I think
what
the
we
defense.
do in trials, we have jury instructions and we have causes of action. You say, here's what you need to find.
Correct. And I think the defense is the jury instruction for the defense would be if you find that defendant was unaware of and therefore unable to invoke the policy's appraisal provision prior to suit. In other words, if it was unaware of there being a dispute, then there can be no breach of or confession of judgment to the breach of
Mr.
contract.
Graff, I'm sorry to derail you. In the sort of traditional Wallard context for confession of judgment, my general understanding is that the plaintiff seeking fees in that setting would move, the insurer just spontaneously, typically the way a Wallard type confession comes up is the insurer gets sued and issues a check to the insured. There's not an appraisal, this is a variation on that theme, right, with the appraisal. And then the plaintiff moves for a determination that the defendant confessed. And what I'm struggling with, and it's more rudimentary, I think, or maybe just less informed than the whole how to get this to a jury question and elements of the cause of action for breach of this policy, is why your client, confronted with what we all agree is a difficult or not a charted landscape procedurally, why your client didn't file a motion. And I understand your argument that you needed to have a judgment to be entitled to fees, but a big part of that argument is that your entitlement to judgment is based on a confession, and you never ask the trial court to make that determination. And I understand that you're talking about, that you were still taking discovery 8 months later and whatever, but it just troubles me that piece of this record is not here.
We weren't taking, or plaintiff wasn't. I'm sorry, I keep saying plaintiff. I apologize to the court. Appellant wasn't taking discovery because it wasn't being given, and to file a motion for confession of judgment without knowing what facts and evidence you're going to be presented with would ultimately be fruitless and a waste of the court's judicial resources. If we file a motion for summary judgment saying, as a pleading sit, we're entitled to confession of judgment, and then defendant files an affidavit saying we didn't know that there was then you
open it up. You open it up for discovery at that point. Say, Judge, listen, there's now a dispute. Now we need to have discovery because now you know.
Well, there's still
the insurer deny your allegation, because I think it's at paragraph 15 of the complaint regarding the demand or the request for payment.
And Mr. Graff, go ahead and answer Judge LaBritte's question. Just to let you know, you're coming into you're into your rebuttal time.
Yeah, I think it might, if the court would allow me, I think it might make sense to hold that rebuttal time for now and address Judge LaBritte's question afterwards, so I have some time to look at that.
It's up to you. All right.
I'll go ahead.
Works for me.
Okay, perfect.
Mr. Hall.
Good morning, Your Honors. May it please the court. Kenneth Hall on behalf of the appellee in this case, in this first case, FedNat Insurance Company. And my position this morning, Your Honors, is that this case and the decision of the trial court should be affirmed for 2 reasons. First is in keeping in mind with what's actually on appeal. It's a final judgment entered after FedNat's motion for summary judgment on the breach of contract elements of plaintiff's complaint. And it's as a result of the parties entering into and the trial court signing an agreed order granting FedNat's motion for summary judgment, which in effect negated those breach of contract.
Well, let me talk about that, because you talk about this being a ministerial entry of final judgment based on this partial final judgment. The partial summary judgment just says we paid the appraisal award, and then the insured was like, "Yep, you did." So, what does that do for you? It doesn't say anything about ultimately who prevails. It's just a simple. It's just saying we paid that. You paid the insurance say, "Yep, you paid the appraisal award, and that covers that. We're not going to seek any more damages for whatever was not covered that should have been covered and interest." There's a big leap. There's a dot that needs to be connected to that you're saying is ministerial to say, "Oh no, this is judgment in favor of the insured on the breach of contract claim."
Well, I think that my characterization of administrative and ministerial tasks was actually the final judgment that was entered. So there was a gap between this agreed order on the summary judgment motion being entered.
Okay, so what was resolved after this partial summary judgment order that you're telling me that all it took was just a ministerial entry of final judgment?
Yes.
So now you're saying something different. You're saying it's not ministerial. Something happened during the interim, or maybe I'm wrong about what you're saying.
No, Judge. Let me address the first part. So I think the question was, what was the effect of the agreed order on defendant's motion for partial summary judgment? What was its effect other than to say that the appraisal award had been paid in full? Well, I would point to that statement itself as what its effect is. It says the appraisal award had been paid in full within the time limits required by the policy. Plaintiff is entitled to no further benefits under the policy. That negates any continuation of the breach of contract cause of action. Once we get back to the black letter elements of breach of contract, we have a contract, a breach, and
I'm sorry, it may be me, but I'm having a little trouble. Someone mentioned an elephant in the room, and the elephant that I see, and maybe it's an apparition and no one else sees it, is that doesn't resolve the contract claim. We've just been talking about confession of judgment. We've in the timing of the payment of the appraisal award, and it's post suit, and then an exception to confession of judgment. And you're telling me that partial final judgment resolved the contract claim?
It resolves the breach of contract. And so what's important to keep separate is the breach of contract inquiry is wholly separate and apart from the entitlement to fee inquiry.
Except it isn't. I mean, we all know this now, right?
Judge Lucas, could you mind if I just respond to that real quick? I didn't say anything about fees. You just said something about fees. And that's another thing. It seems like you're making the straw man argument where you're saying that the insured keeps jumping to the fees. I didn't jump to the fees, and I'm not sure they did either. I'm talking about the breach of contract claim, and you jumped the rails by saying, well, that has nothing to do with fees. I'm talking about the question of, isn't there something besides the sheer fact that the appraisal award was paid that determines whether the cause of action of breach of contract has been supported?
No, and I actually disagree that a post.
Sorry, Judge Lucas.
Go ahead, Mr. Hall.
My position is that a post-suit appraisal award payment pursuant to a contract is not a breach of contract. And I think the logic of summary judgment in the insurer's favor when an appraisal award is paid post-suit is sound.
You want us to be the first court to hold that, because no court has ever held that. Correct?
There's no case law to the contrary either, Your
Help
Honor.
me try my question, Mr. Hall. No court has ever held that post-lawsuit, post-appraisal payment, an insurer is entitled to judgment in their favor. We would be the first court in Florida to hold that.
But I would actually refer the court to the Velez case, which I actually cited in the reply in the case where FedNat is the appellant. But that's a third district case that is strikingly similar in terms of its procedural posture, where the court did say that summary judgment post appraisal was appropriate for the insurance company. And
was that the one that was an instance where it was the insurance company was not aware of the lawsuit?
I
Is
don't
that
I don't know.
case?
I don't know if that was the facts that were developed in that case. That is the substance of the confession of judgment argument. I mean, that's what needs to be fleshed out at a 1.525 motion for entitlement.
Could you spell Velez? I mean, I don't. Sorry.
Yeah, VELEZ.
And was that in the which brief? In which case did you file that? The fees appeal or the?
Yes, Your Honor.
Oh, okay.
PFS
So we're
appeal.
still on the first appeal.
I understand, Your Honor, but it's a case that's
It's in,
relevant.
but we would be looking for it in your reply brief for the second appeal. Is
Yes,
what
Your
you're
Honor.
telling us. Okay.
Okay.
Okay. Fair enough.
And just to briefly, talk about the facts of that case, it was a post-suit appraisal award payment. It was a case that the insurance company paid appraisal post-suit. They filed a motion for entry of final order of dismissal with prejudice and/or a motion for summary judgment. In response, the insured said there was additional evidence to be considered and that he was entitled to fees. The insurer said there's nothing left for the court to determine on breach of contract because the appraisal award had been paid, and so the insurance company's obligation under the insurance policy had been satisfied. The trial court denied the insurer's motion, and the third DCA reversed that. And they said it was error to deny the insurer's MSJ on breach of contract because I'm quoting from the opinion here, it said the undisputed evidence shows that USAA fully complied with the policy in paying Velez's claim. Indeed, Velez conceded this point on the record, and I would analogize that with what happened in this case when Appley, in this matter, entered into the agreed order on summary judgment that FedNat had fully complied with the policy by paying the appraisal award in full and timely. And so to return to the quote here, the third DCA says, because there were no material facts in dispute, and because Velez had neither put forth neither opposition to USAA's motion for summary judgment, nor any evidence otherwise in support of his single claim for breach of contract, USAA's motion for summary judgment should have been granted. Now, the important point here is that that court left the fee entitlement inquiry separate. So this is illuminating the notion that the breach of contract analysis in question is to be divorced from the separate 1.525 motion for entitlement to attorney fees inquiry. So this is a case where summary judgment was granted in favor of the insurance company in a post-suit appraisal award payment case. And to return to what I was saying earlier, I think the logic of that is sound because in terms of the timeline of this case, when the appraisal was ordered, the litigation was stayed. So I think that's an important component here. This isn't like an arbitration or any other type of alternate dispute resolution. Appraisal is a creature of the insurance contract. It wouldn't exist unless it was called for in the contract. So once the case was stayed, the trial court judge was essentially telling us, get out of my courtroom. I don't want to deal with this in terms of
putting it in really simple, dumbed down terms, right? The insurer is not disputing coverage. That's the only way you get to appraisal. And the purpose of that proceeding is to liquidate and establish the amount of the benefits that the insured is entitled to in an alternate fact-finding tribunal for very simple resolution. And I think the cases that you're pointing to, or at least as I recall reading them, is that I think without having said it explicitly in the context that we have now, your argument is that the courts are viewing the appraisal process as not a judicial determination of benefits in an adversary situation the way it would be if it had to go to a jury.
That's exactly right, Judge. And that's what this court said in the Hill case from 2010, where the court says appraisal is not a process to resolve a breach of contract claim. It's not for coverage disputes. The quote from the Hill case says appraisal is a method of adjusting a claim within the terms of the contract. And so this case is totally on point here in terms of what the court envisioned to be left to do with the breach of contract claim after appraisal is paid. It says, thus in this case, in the Hill case, After the appraisal process was finished and the insured had never or had been paid the remaining benefits, her attorneys never really identified a loss that had not been covered in the adjusting process or any aspect of the appraisal procedure that had been improper. In other words, once the appraisal was concluded, the insured does not appear to have ever had a remaining claim for breach of contract that she could articulate. And so my point here is, what does it mean when the Hill Court says you've got no remaining breach of contract claim to articulate? It means that breach of contract is over. The contract has been.
And getting back to sort of the record here, right? The order that was agreed to on the summary judgment motion says that plaintiff is entitled to no further benefits. The court declined to make a determination as to breach of contract, which I think it carried through to the final judgment, and it reserved jurisdiction to determine entitlement and the amount to be awarded, if any. And how long, that was entered in August of 2019. How much time elapsed before you went back and asked for the final judgment?
5 months, Your Honor. So the summary judgment motion was filed in June of 2019. In August of 2019 is when we have the agreed order on the motion for partial summary judgment, specifically reserving on fees. And this timeline highlights every opportunity that appellant had to file its 1.525 fee motion, yet never did. So the agreed order is entered in August. 5 months go by with no record.
But you can't enter a 1.525 motion on an order.
That's exactly right, Judge. And that's
The rule
why,
says it has to be a judgment.
That's
And
right.
here, because of the judgment that you obtained, it has the happy coincidence of being a judgment in the insurance company's favor, even though there was. But help me out on this, just substantively speaking, in what universe is a defendant entitled to a judgment in their favor when they have post lawsuit paid damages to the plaintiff?
Because the payment wasn't as a result of the lawsuit. The payment was as a result of complying with the contract via the appraisal process.
When was that
And that,
adjudicated?
again, I'm sorry, let me finish real quick, please.
Sorry.
That goes to the that goes to the point that what you really want is for a court to hold that when parties proceed in an insurance contract to appraisal post lawsuit, once the appraisal is paid, the lawsuit it's as if it didn't exist. It is ex nihilo. It is no more. That's what you want the law to be, but it's not there yet. Correct?
There's no case that's on all fours with this particular circumstance, Judge. That's right. This is an analysis that strings together the holdings from Hill and strings together the basic concepts of.
Well, let me tag you real quick, and then I'll turn it over to Judge Atkinson because he had a question on Hill. What part of Hill would you say is binding holding, and what parts would you say were dicta? And I ask that legitimately because on the one hand, in Hill, we affirmed and remanded for these determinations about rushing to the courthouse, and yet the direction at the end is that we were reversing. We offered guidance to the court, to the circuit court, about what it might want to consider at a fee hearing, although it didn't look like that was an issue that was before us. So how would you parse out what parts of Hill are binding holding and what parts would you say look like just kind of guidance dicta?
Sure. So the parts of Hill that are binding holding is the reversal due to the simple fact that there were legitimate facts in dispute in the record as to the claims adjustment process and the run up to the lawsuit. So there were legitimate disagreements about the timeline of events from the insurance company's perspective on one hand, from the Hill's perspective on the other hand, what coverages were opened, what payments were made, what communications were sent back and forth between the insurance company and the insured. And the Hill court's specific holding was summary judgment on any issue, on breach of contract, on entitlement to fees, is inappropriate when there are legitimate, disputed issues of fact, which is what undoes summary judgment in every case. So that's the specific holding. But in this case, there are no disputed issues of fact that have been developed in the record. So there was no 1.525 motion filed where there could have been an issue one side is saying one thing in terms of the lead up, and the other side is saying the other. And so we don't actually get to the specific holding in Hill in this case because there are no facts in dispute. The guidance that the court gives is
how do we know there's no facts in dispute on that issue when the issue of rush to the courthouse isn't one that's pled?
Because it should have been part and parcel of a 1.525 motion for entitlement to attorney fees.
But that can't be entered until a judgment's entered, right?
Yes, Judge. And that gets back to the point that you raised earlier about what does this agreed order on the motion for summary judgment get us? And what, it's sort of ineffective and impotent in a way until it's converted into a judgment. And so that was the purpose of filing the motion for entry of final judgment after, again, 5 months of inactivity from.
See, I'll call you on, if you're going to get to what was the purpose, I'll call you out on that. If indeed the purpose was to get to finality, why not just agree to a judgment in the insured's favor with a zero amount owing with fees and costs to be determined later? It does the same thing.
That was never an option that was presented to FedNet.
Help me out. Why not run it up the flagpole that way? Hey, listen, we'll agree to judgment entered in favor of Synergy, but listen, it's going to be a zero amount owed on the policy because we paid all the policy. We just got this partial summary judgment here, or summary judgment order here, reserved to fees and costs, and then that puts them on the clock, 1.525, right?
Sure, Judge. But again, my position is that, and I know that this may strike as novel, but the insurance company, I believe, has actually prevailed on the breach of contract action when it does.
Yeah, all roads lead to this vein of law that you really want us to hold. That's kind of what I'm gathering from the argument that you all have made.
That's part and parcel of it, Judge. But
yeah.
But one, I mean, regardless, I mean, I think the point was raised earlier that this notion of getting to a final judgment could have been avoided if the appellant had simply acceded to the order that was, shot across the bow that says, hey, we've paid the appraisal award in full. Let's just, dismiss the remaining cause of action, because cause of actions need endpoints, right? They need to be wrapped up. They can't just be hanging out in perpetuity. And so agree to dismiss.
Parties don't like to end them when they're the loser, though.
Who doesn't like to end when it's the
parties typically aren't eager to end them in a result that suggests that they're the loser.
I know, but an agreed order dismissing a cause of action with prejudice after your client has been made whole. So that's something else to keep in mind here, is that with the appraisal award payment, the real party in interest here had been made whole. So to suggest that the AOB contractor itself would have been a loser by agreeing to dismiss its breach of contract action after it had been made whole, I don't think makes a lot of sense. The only thing that's left after the real party in interest gets made whole is whether or not it has to pay for its fees and pay for its own attorney fees and follow the American rule, or whether or not we act in derogation of the common law, right, and stick it to the insurance company to pay for their attorney fees and costs. So the most efficient route to get to the only issue that actually ever mattered in terms of the litigated issue in this case would have been to dismiss the cause of action with prejudice, reserve on fees and costs, and then litigate the issue of entitlement to fees and costs once a 1.525 fee motion is filed. And that's the other thing I think that is being overlooked here, is the necessity of a 1.525 fee motion in order to get your attorney fees. There's been some talk about how would that be incorporated into some jury instructions, perhaps, or added onto a verdict form. But I think there is definitive. That's
not what I was talking about, but go ahead.
Well, I'm sorry to mischaracterize it, Judge, but
it was about how you resolve the breach of contract.
Breach of contract
in a jury trial.
There would be none. There's no need for a breach of contract in a jury trial because there are no damages and there's been no breach. So that's the purpose of it ending.
See, and that's where, and I'm letting you go over a little bit because we've been peppering you with a lot of questions. That's where arguably there is a dispute because arguably there could still have been a breach by the failure to pay necessitating the appraisal process. That could arguably be a breach. It would be a breach without compensable damages by the time you get to the jury trial because the damages have already been paid. But under contract law, even nominal breaches entitle parties to redress. You can seek a breach of contract action and prevail, even though there hasn't even been a material breach. It can be an immaterial breach, and you can still seek redress.
Are
But you need to
fees
have-
the same, are fees part of the benefits payable pursuant to the policy?
No, and that's where I would disagree with the cite to the Palma case. The Palma case does have a narrow holding, in that it's you can get fees for litigating fees. I don't think it in any way suggests that fees are part of the damages.
Actually, what
Yeah.
Palma says is you can't get fees for litigating.
You get fees for litigating the issue of entitlement to fees. So if entitlement is contested, then your fee clock continues to run. Once entitlement is decided and it's only about the amount, that's when the fee clock stops. But Palma interestingly says, after a voluntary payment is made, that rendered moot all issues other than the question of attorney fees. So again, Palma itself stands for the proposition that the fee inquiry and the breach of contract inquiry are separate. And
But if it's moot, you don't get a judgment in your favor. You would get dismissal. And I don't know if it would be dismissal with prejudice, because that would be considered an adjudication on the merits.
in however it ends, it needs to end. And so this was the only way that I guess my bottom line point here is that this was the only way that this case was ever going to end, because
I thought Judge Lucas just proposed a different way to end it. A judgment in favor of the insureds for $0.
sure. And then a 30-day timeline to file a
That sounds like a different
1.525
way.
motion. And in this case, judgment was entered, and the 30 days went by without a 1.525 motion from the other side. So appellant had every opportunity to file its 1.52 motion if it wanted to. It didn't. It's waived it now. And I'll conclude just by saying that this court should affirm the lower court's holding that the breach of contract had been rendered moot, or at least had been decided in the insurance company's favor, and that if you don't file your 1.525 fee motion, then you've waived your opportunity to make that
All right.
rush to the courthouse entitlement argument. Thank you.
Thank you, Mr. Hall. Mr. Graff, you've got 5 minutes.
Thank you, Your Honor. A lot to cover there. I'll briefly start with this repeated notion that 1.525 is the method to deal with this, and that a plaintiff or appellant simply should have agreed to a dismissal with prejudice of its case, and then file a 1.525 motion asking for fees on a case that it dismissed and that it didn't receive a judgment on, or the equivalent of a judgment on, which would be a determination of confession of judgment. Except that's impossible, because there's no way to file a 1.525 motion seeking fees under 627-430 or 138 or 428 unless you have a judgment in your favor. And by the way, Judge Lucas, I take the court's point there, and that's what was brought to the court's attention as a means for if the defendant really wanted to bring this to a head, all the defendant had to do was stipulate that its payment amounted to a confession of judgment in plaintiff's favor, and then we have a fee hearing afterwards. But defendant was refusing to do that. It was refusing to do that through its proposal to dismiss with prejudice. It was refusing to do that as reflected in the agreed order, where the only thing that was agreed to, as Judge Atkinson pointed out, was, yeah, you paid the appraisal award. That, yes, that does resolve the underlying benefits that were due for damage to the property. That doesn't resolve the breach of contract action, which is necessary to be resolved before we move on to any 627-428 hearing. And it doesn't resolve attorney's fees. And that's why that order didn't say anything. And Judge Libritt, to your point, yes, the final judgment didn't go so far as to find that there was no breach of contract, but it did end the judicial labor. And so it became impossible for plaintiff to, at any point at that juncture, move for fees, because there was no judgment and there was no finding of either breach of contract or confession of judgment to breach of contract at that point. Hence,
Couldn't the plaintiff have filed, I mean, what would have been the harm of filing a 1.525 motion at that moment to ask the court to determine confession and entitlement based on it?
the harm would be adopting the defendant's viewpoint that this is how you do it, that you're filing this motion, you're acknowledging that the issue of breach of contract and confession of judgment are separate, are separate, and that you can resolve the lawsuit in the insurance company's favor, and then afterwards try to argue that you've won under 627-428, and at that point you're owed fees. So admit that you've lost, then file a motion that says you actually won, and then get fees. It logically doesn't make any sense, and that's the position that plaintiffs put in. And plaintiff was asking for discovery, was pursuing knowledge of what defense they were going to pursue when defendant took the action of asking for a motion for entry of final judgment, saying that somehow plaintiff had agreed that defendant had won because it had agreed to an order saying you paid the appraisal award. I do want to address as well, if the court will allow me, this idea that Hill somehow was a departure from Clifton, Goff, Beverly, and that it was a finding that payment of the appraisal award resolves the breach of contract action or moots it. I don't believe that's what Hill says. If you go through and read Hill, first of all, there's a pretty complicated procedural history in terms of complaints, amended complaints, counterclaims, that sort of thing, and when these appraisals were happening. And second of all, the court made it very, very clear that under the facts of that case, it had serious questions whether that lawsuit was filed simply for the purpose of generating attorney's fees, or whether there was for the usual process of negotiating an insurance claim, or whether there was a bona fide dispute, which is a rush to the courthouse argument. And ultimately, the Hill court reversed and remanded for that rush to the courthouse argument to be had. So Hill ultimately did exactly what plaintiff is asking this court to do, and what plaintiff was asking the trial court to do, which was don't enter any judgments until we have a determination on this rush to the courthouse defense that was raised by citation to Goldman in the motion for partial summary judgment. We have to have that out. We have to resolve those issues before we have any kind of final judgment entered. And as Judge Lucas has pointed out, there is simply no case law that suggests that where an insurance company invoking and paying appraisal after suit for the first time post suit, that they have simply won. And that is what defendant is encouraging this court to do, which is to reverse its precedent in all of these cases. And it's not just asking this court to do it. This argument has been raised before in federal district court in Astor-Kiza, which is another case cited. And the court went through the exact same analysis that I've taken the court through today in that case. And the court ultimately found, no, Florida case law is pretty clear that insurance companies don't win in that situation. It doesn't moot the breach of contract action. Palma and 627-428 made clear that these issues need to be addressed. This rush to the courthouse or the idea of confession of judgment needs to be addressed prior to a final judgment. And ultimately, the court in that case set up a case management conference to figure out what the best way of going about achieving that was. And certainly that was available here. I understand Judge LeBrit's point is plaintiff, you should have filed a motion for summary or for entry of judgment in your favor, and you didn't do that. It was plaintiff's position that it needed further discovery before it did that. Regardless, it was also plaintiff's position that we are already on a trial track because this is a trial.
To be clear, part of my position is that the plaintiff wasn't prevented from, upon entry of the final judgment in this case, putting down a motion that maybe would be at risk of denial, depending on how the judge received it, but that having never filed a paper saying I'd like a determination of confession, the plaintiff has left us with a record that makes it a little bit difficult to get exactly where you would like us to go from here.
I understand that, Your Honor. I mean, the transcript makes very, very clear that it was argued to the court, and the court was well aware of plaintiff's position about where this needed to go. It was the exact same arguments raised at trial court that are being raised here. So the court was certainly aware of, and so was defendant, of what plaintiff's position was about how this needed to be resolved, which was that the breach of contract needed to be resolved. It wasn't resolved. That's why there was a specific reservation of it in that agreed order that defendant is somehow arguing was a resolution of the entire case. And it was communicated to defendant that plaintiff wanted that resolved. And the court was aware of that too. The breakdown became when the court was trying to figure out how to do that. And the court was persuaded that it could enter judgment in defendant's favor. And then after that, a 1.525 motion could be filed by plaintiff saying, okay, defendants won, but we're still going to ask for fees pursuant to 627-428, which requires us to win a judgment in our favor. And that was the issue for plaintiff.
With that, unless there's any other questions on I'll call it the summary judgment, final judgment portion of these two cases. If there's no other questions on that, why don't we transition over, switch hats, and go to the fee order appeal, which in this case now, Mr. Hall, you're now the appellant. Same as before, you want to reserve time?
Yes, Your Honor. Thank you. May it please the court. I'll reserve 5 minutes for rebuttal, although I think I'll be brief.
I was going to say, gentlemen, we've covered a lot of ground that I think covers both appeals. So, but you've got your time, so use it how you wish.
Thank you, Your Honor. And again, I will be brief, but this is, of course, this argument, of course, is predicated on the final judgment in FedNet's favor remaining intact. So I will say that at first. But the position here, Your Honors, is that the order denying FedNet's entitlement to attorney fees should be reversed because the trial court applied the incorrect prevailing party standard when it did the analysis under the PFS statute. The trial court ignored the fact that FedNet, in fact, obtained a judgment of no liability. And the second reason, Your Honor, is that the enforcement of the sanction of fees against the appellee now for dragging out litigation over attorney fees, but never filing the requisite motion, fulfills the purpose of the proposal for settlement statute and scheme. And so just as a brief return to the timeline here, after FedNet paid the appraisal award in full in May of 2019, and the appellee refused to dismiss the cause of action and go straight to the only substantive issue that was left, which is the issue of attorney fees, FedNet files a proposal for settlement in June. So this is after the appraisal award's been paid in full, after the offer has been made to dismiss the case, go straight to entitlement. So realizing now that this is not going to go away in any sort of efficient or smooth manner, FedNet needs to use this tool. So the proposal offered some money in exchange for a global release and a dismissal with prejudice. It wasn't a lot of money, but it was an amount of money that was reflective, I think, of FedNet's confidence in its position that in the event that a 1.525 motion is filed and that an entitlement hearing is had, FedNet was confident in its position that under the circumstances of this case, under the facts of this case and the run up to the filing of this lawsuit, appellee would not be entitled to its fees and costs. And so after the PFS is filed, the history of litigation that we just described ensued up until the case was concluded in May of 2020 with the final judgment about a year later, with the net result of all of that extra work, all of the extra legal fees that FedNet paid its counsel, all of that results in appellee receiving $0. And so after the judgment was entered, FedNet follows the rule of 1.525, the 30 days, the 30-day timeline, that's the bright line deadline, files its motion for fees using the argument of the expired proposal for settlement as its basis. Contrastingly, appellee could have filed its 1.52 motion at that point, which is, bleeding over into a little bit about what we talked about earlier, but its argument, its basis, its substance for its 1.525 motion would be its confession of judgment, rush to the courthouse.
You would agree with me that had what I'd proposed earlier, that had a judgment been entered in favor of the insured, but zeroed out, would the proposal for settlement, would you have been able to move for proposal for settlement as a prevailing party unless, and I'm just tying this back, we got to your notion that's kind of prevailing the prior appeal, which is that, well, we must have prevailed because we paid the appraisal.
Well, I think that we need to be careful with our nomenclature there because, again, it's not prevailing party under 768.79, which is the PFS statute. So, but addressing that hypothetical specifically, if there was a judgment that was entered that had language that says judgment in favor of appellee Synergy, but for $0, yes, I do believe that FedNet would be entitled to make the argument for its entitlement to fees because $0 is a judgment of no liability. And that's what the 768.79 says is the standard. So it doesn't require the offering party to prevail over the other, but it instead conditions the award of fees as a sanction on whether the offeror obtained a, quote, judgment of no liability. And I've cited case law in the brief that says a defense verdict in which the plaintiff recovers nothing is the equivalent of a judgment of no liability. And if a plaintiff recovers nothing, that's always less than 25% of a defendant's offer of something. And so that goes to the
But
other.
if a judgment, if we accept our prior holdings in golf, et cetera, and the Florida Supreme Court's assessment of how these claims are supposed to be construed, which is that the fee award is part and parcel of the judgment and the judgment reserves jurisdiction to award fees, wouldn't that necessarily be baked into the case? Wouldn't that come into the ultimate final judgment that has to get entered, which would include a fee award? Unless we accept the notion that you have been advocating, which is that, hey, payment of the appraisal, done.
Well, I disagree with the premise that Goff and Palma and that the other cases that you mentioned stand for the proposition that fees are part and parcel of breach of contract. And I'll return to my argument that says a 1.525 fee motion is required to get fees. And it, we have this idea that it's just one judgment, but if you look at the text of 1.525, it says any party seeking a judgment, taxing costs, attorney fees, or both shall serve a motion no later than 30 days after filing of the judgment, including a judgment of dismissal or the service of a voluntary dismissal, which judgment or notice concludes the action as to that party. Why would the rule mention judgment twice, considering it's not, in other words, not considering it as a singular thing? It's two judgments here that are being contemplated. It's a judgment on the underlying.
And wasn't that language in place when Palma said what it said and when our court said what it said?
Yes, Judge. But again, I think Palma is a narrower holding than this notion that fees are going to be somehow part of. I mean, we can think about it in terms of some. We can do a thought experiment here about how would a trial look. If appraisal was never invoked here, and this was just a regular breach of contract jury trial. The dispute, in essence, is did the insurance company pay enough? Because this was a covered claim. It's not about coverage being afforded or not. It's just about the dollar amount. So the insurance company on one hand would say, we paid enough. Plaintiff on the other side would say, you didn't pay enough. The verdict form would say, did they pay enough? And the line item for damages would be the amount that the jury finds is the correct claim payment. The jury doesn't hear a word about entitlement to fees or the amount of the fees. That's not something that's ever properly in the province of the jury. What happens is you get the verdict that says breach or no breach, the verdict number, which is the damages amount, maybe a motion for remitted or added or after that, that gets reduced to a judgment. And then 1.525 says, file your fee motion within 30 days of that judgment. There's case law that suggests that this is a two-step process. I've cited the Kelly case, and in that case, the trial court entered a final judgment in favor of the plaintiff. The judgment included damages, prejudgment interest, and costs. And the defendant objected to that inclusion of costs, and they said that's improper to include costs because no motion for 1.525 fees and costs was ever filed. And the court said, quote, it is not sufficient for a party to plead entitlement to fees or costs only in their pretrial pleadings, such as in a complaint or an answer. A timely motion is also required. So back to my, trial hypothetical, the jury finds breach, puts the number on the verdict form, that gets reduced to a judgment. A separate timely 1.525 fee motion is required if plaintiff is going to try and get its fees. That's also recognized in the Duncan Seawall case, which is a second DCA case from 2008. And it says, even if a trial court enters an order finding that a party is entitled to fees and reserving jurisdiction on the amount, the party must still serve a timely motion under Rule 1.525. Thus, Rule 1.525 is a bright line rule that is strictly applied. So you've got to file your fee motion if you want to have that issue heard. So I know that bled back into the initial argument, but the second point of my argument here with regard to the enforcement of the PFS is that this was in fact a judgment of no liability. The opposite claim that payment of an appraisal award was somehow a partial admission of liability or a partial confession that the insurance company had in fact breached the contract, that is totally opposite than reality. The payment of the appraisal award was the very fulfillment of the insurance company's contractual obligations.
I'll take you to task on that, Mr. Hall. The fulfillment of the obligation is to pay the amount of damages within the policy limits that measure to the insured's loss. The appraisal process is simply a way of determining when there's a dispute about what that amount is. An appraisal award in favor of an insured means that the insurer failed to do that.
It's not I would vehemently disagree with the concept that it's a failure, because that everyone knows. I mean, that's the
only put it this way: the insurance company did not volunteer that money. It only paid it once everybody went through the time and expense of going through the appraisal process, hiring. Is this a 3 appraiser provision? Yeah, hiring 3 appraisers, paying them their hourly rates plus the lawyer's hourly rates in order to go through this alternative dispute resolution process to determine what else the insurance company was supposed to pay on its contract. How is that not a failure to pay what you were supposed to pay on the front end? The idea is that when the insured makes a claim, the insurance company under the policy is supposed to either deny coverage if there's a basis to deny it, or to pay the claim the amount that is owed. Didn't do that, then had to go to appraisal, and then after the appraiser said the amount you had to pay extra, then and only then did you do it.
Yes, because I think that the notion that the insurance company is obligated at the outset to pay the amount of the claim, and that's it. That is not
or deny it.
Or deny it. But that's not the end of the story, because the process for sussing out the amount of the loss, if it's disputed, is the appraisal process in the contract. This is a bargain.
No one's expecting any party to just lay down and die, metaphorically, in the litigation. But the point is that we have winners and losers. So the simple fact that let me ask it this way. Okay, there's this legal fiction or whatever the proper legal law thingy it is. It's a confession of judgment. What is the judgment being confessed?
The confession of judgment doctrine, Judge, is something to.
What is the judgment being confessed?
The judgment being confessed is that a payment was made post suit.
No, what is the it's that's turning it on its head. In other words, you're confessing that you owed more than you originally were going to pay.
Yes.
Right. So you're confessing that you breached the contract by virtue of the policy, the contract. You should have paid X, and now you paid it. Isn't that inherent in the confession of judgment? I still do want to answer my question, though. I've described it the way I want to describe it. What is the judgment being confessed in the doctrine of a confession of judgment?
Right, but I think an explanation.
What is the judgment? What does the judgment would say? You're confessing to what judgment? What is being adjudicated?
That you've breached the contract.
Yeah, thank you. So that's the elephant in the room here.
Right, but the confession of judgment.
You want to turn that all on its head and show us the roadmap to get to turning all that on its head. All the case law that talks about the timing of the payment of the appraisal award and when you go to appraisal and when suit is filed. How do we get to a result that seems to me to turn all this case law on its head?
There's no reason to turn anything on its head. That the confession of judgment argument, whether or not the substance of the argument, the actual law that's not even really relevant here because the motion hasn't been filed, is whether or not there was this quote unquote rush to the courthouse, and whether or not the claims adjustment process reached an impasse. That's the elephant in the room. That's the heart of the issue, is whether or not this was a scheme that this AOB contractor put in place to rush to the courthouse, file suit, and get its lawyers paid for the regular process of adjusting a claim, going through the appraisal process, perhaps voluntarily on their side first. That never happens. And so the question ultimately, which is the subject, and my point here, the subject of the 1.525 fee entitlement inquiry, is whether or not the insured was forced to hire a lawyer to get the insurance company to do what the contract says. That's different than hiring a lawyer who prevails on a breach of contract claim. And that's what the Hill Court says again in dicta, but it's the fees that an attorney would be entitled to in this circumstance as the prevailing party under the confession of judgment doctrine is what you did to get the insurance company to go back to the contract and adjust the claim within the contract. You don't get paid for the appraisal process. You don't get paid for all the extra litigation that occurs after that. It's really supposed to be, what did you do as an attorney to force the insurance company to come back to the negotiating table and adjust the claim within the contract? That's not the same as proving a breach of contract and doing legal work to prove the elements of breach of contract, when again, my position is there are none. They've been extinguished. They evaporate the moment the appraisal payment is paid. But again, to return to the PFS argument here, and I know that we've gotten a little bit far afield from that, this was a final judgment of no liability in the insurance company's favor. And the sanction of fees in that circumstance is mandatory. It's not discretionary, and it's totally in line with the purpose of the PFS statute. So the case law says it's to promote a level-headed assessment of the chances of success on a claim, discourage frivolous litigation, and to promote judicial economy. Once the appraisal award had been paid and the only thing left to litigate and argue about was entitlement to fees and costs, FedNat gave the appellee an opportunity to make a level-headed assessment of its success on its fee entitlement claim if it was ever going to make it, not delay things and promote judicial economy by offering some amount of money that FedNat assessed to be its reasonable risk in terms of whether or not it thought it would prevail on the ultimate fee entitlement question. Rather than accept that and take that money within 30 days of when the PFS was filed, appellee continued the litigation for another 11 months until FedNat finally obtained the judgment of no liability in May of 2020. And so how is this promoting the purpose of the PFS statute? Appellee prolonged the case unnecessarily by failing to dismiss the action and go straight to the issue of attorney fees and costs as FedNat proposed. And then it caused further unnecessary delay by rejecting the offer, never filing its own motion for fees and costs, requiring FedNat to file 2 more motions, attend 2 more hearings to conclude the case with the net result of $0 being awarded to appellee as a result of the litigation. And again, that's so critical to keep separate here. The appraisal payment was not paid as a result of litigation. That was paid while the case was stayed outside of the litigation context. The lawsuit itself resulted in a net result of $0 to appellee. So instead of accepting $100 a year earlier, the case concluded with appellee getting $0. But FedNat is paying its counsel all along the way to get there. And so that's the set of facts that exemplifies the scenario that the statute was designed to avoid. One party continuing to have to pay costs and fees for another party's efforts that ultimately result in something worse than it would have gotten if it had accepted the proposal for settlement a year in advance. So in conclusion here, the sole reason that the trial court denied FedNat's entitlement to fees, which was clearly articulated in both its oral ruling and its written order, was its finding that FedNat did not prevail. But this was error requiring reversal because
Mr. Hall, you're getting into your rebuttal time.
Thank you, Your Honor. And I'll just finish and say the standard is not prevailing party. It's a judgment of no liability. FedNat obtained that when it obtained the $0 final judgment in its favor on the cause of action for breach of contract. Thank you.
Thank you. Mr. Graff. Mr. Graff, you're muted, sir.
I apologize. Thank you, Your Honor.
It's all right.
I'll start where Mr. Hall ended, and I'll hopefully be brief there. The final judgment does not find that there was $0 liability in favor of defendant. The final judgment states that the defendant paid the appraisal award in full and in the time required by the policy. And then it said this ends the judicial labor. Paying the appraisal award is money in Synergy's favor. It is confession of judgment. That goes back to the last argument we had. I understand that the court's well versed in that now. I'll continue by kind of pointing out what defendant what I believe a appellee in this case or appellant in this case and appellee in the other case is trying to argue, which is essentially that insurance companies can do exactly the opposite of what Clifton says. They could sit on a dispute, knowledge of a dispute, wait for a suit to be filed, invoke appraisal, pay it, say that paying it is within the confines of the contract, and therefore they didn't lose, they didn't do anything wrong, there was no breach of contract, pursue a final judgment in their favor, and then send a PFS out and say we have a final judgment in our favor because we pay the appraisal award, and therefore if you ask for any fees, you owe us fees. That's what defendant is at, or appellee, I'm sorry, appellant in this case, appellee in the other case.
You just call them the insurance company. It's fine.
The insurance company. That's what the insurance company is asking this court to do. As I think the court has pointed out, that would be to turn all of the current case law on its head. It would be to reverse Clifton, reverse Goff, reverse Beverly, reverse Hill, reverse Palma, or I guess not reverse Palma, but
Yeah.
certainly find inconsistent with Palma. And it wouldn't be to follow the statute. So with respect to the actual PFS arguments themselves that were briefly addressed there, there were three arguments against the PFS that were made at the hearing. The first was that there was no judgment of no liability because plaintiff was the prevailing party because it received the appraisal award. Ultimately, the court granted or denied the motion, granted the insured or the Synergy's objection on that basis. But there's also two other bases that weren't ruled upon. Briefly, those were that this wasn't made in good faith. Mr. Hall argues that based on a clear-headed assessment and following the statute, it offered $100. Based on the only case law that's available right now, there was no basis for the offer of $100 for fees, not as the record sat when that offer was made. And when nominal offers are made, there has to be record evidence to support them in order for them to be made in good faith. And there simply wasn't any record evidence to suggest that the insurance company could anticipate paying $100 in attorney's fees in a situation where it invoked and paid appraisal post-suit and hadn't established any rush to the courthouse defense. So for that basis, believe that the court's order can be upheld. The court didn't address that, but certainly Mr. Hall has in his argument. And then finally, there was a third argument, which was the release that was supplied and that plaintiff would have been required to execute, would have required not only the extinguishment of the breach of contract action, it also would have required plaintiff to waive any bad faith claims that it had against the insurance company that weren't part and parcel of this action. Case law is fairly clear on that point, that where you're requiring extinguishment of other claims, that introduces vagueness in the PFS and is a separate reason to deny attorney's fees on the basis of an offer of judgment. So that also was not addressed by the court. However, that would be a separate basis for this court to uphold that ruling. I guess I'll close simply by saying that this argument that there should be a 1.525 motion, that's the only way to go about it. When there has been no determination on breach of contract, to file a post-judgment motion after the insurance company has already been declared the winner, and file a post-judgment motion saying, court, now please do the rush to the courthouse assessment. Now do the assessment that you're required to do to figure out.
Well, this is, I'm sorry.
Sure.
This is my heartburn with this thing all along, is that I don't understand what stopped your client, whether you call it a 1.525 motion or a motion to determine confession of judgment, why your client never filed such a paper at whatever point immediately following the proposal to the proposed dismissal order, when it agreed to the summary judgment order, when the other side moved for final entry of final judgment on that, after the court entered it, a motion to determine confession.
Sure.
That's an evident, according to you, that's an evidentiary determination.
I believe it to be. If the case law talks about the factors that go into determining rush to the courthouse, which is whether the insurance company was aware of a dispute, I believe that to be a fact-intensive analysis. And the answer, I'm sorry to keep supplying it, is that plaintiff was in the process of attempting to provide discovery, and defendant keeps saying that they were this party that had no opportunity to bring an endpoint other than to ask the court prematurely to enter a judgment in their favor when they paid an appraisal. They could have provided the discovery that was being requested. They could have provided the depositions that were being requested. They could have done as Judge Lucas had stated and stipulated that its payment amounted to a confession of judgment, thereby putting a 30-day limit for a 1.525 motion. But a 1.525 motion is not the mechanism. A post-judgment motion isn't the mechanism to determine who wins the judgment. I mean, that simple logic dictates that you can't figure out after the judgment's entered in one party's favor which party won. And that's essentially what the insurance company's argument is that after judgment was entered in its favor, then plaintiff can file a motion and ask the court to determine whether or not it was the winner. And that's simply that's putting the cart before the horse. It makes no logical sense. Getting back to how that plays into the PFS, certainly if this court were to reverse the judgment in the insurance company's favor, that would negate the basis for the PFS. But certainly there are other bases, and that have already gone through the good faith. And,
would it? It might. Could the court reach the same determination if we reversed on the other appeal and the court, which goes to they could say, well, okay, you're right. Could there just be offsetting fees? In other words, yeah, you won and you won because it's still a $0 award. I mean, I know your point, I think, is plaintiff is entitled to no further benefits. Doesn't mean they didn't win anything. But what is the case law that prevents the court from saying, well, okay, fine. Now you get to file your 1.525 motion after there's been a determination by a jury or summary judgment, whatever, that there was a confession of judgment. But you might get fees, but they also get fees on their proposal for settlement because they paid the appraisal award. You didn't get anything. What's the case law that would prevent that outcome?
I think that's the answer to your question, Your Honor. Is for the fees to be offsetting, the court would have to find that Clifton, Goff, Beverly Hill, all those cases are no longer good law, and that when you pay the appraisal award, there is no confession of judgment. They pay the appraisal award, you're fine. You didn't get anything out of the lawsuit.
You're saying that, going back to my point, the confession of judgment is you breached the contract because only after this suit was filed and there was an appraisal did you pay X amount of damages. That is the damages. And so it's not a zero judgment, you're saying.
Correct, Your Honor. I mean, to your point before, what are you confessing judgment to? This is a breach of contract action for the underpayment of claims. That's by invoking appraisal post-suit and paying it, you've admitted, you confessed judgment to the breach of contract. You underpaid the claim. You've lost. You've abandoned. And this isn't something that's novel. This is what the case law says. The case law says you've abandoned your defenses and you've admitted the cause of action by paying the amount of the appraisal award. And so plaintiff has prevailed. And the only way to get around that, I know this keeps going back to the other appeal, but the only way to get around that is this confession of judgment, which plaintiff was seeking discovery on so that it could be appropriately dealt with prior to a judgment being entered, not post-judgment through a 1.525 motion. And so isn't the only way to get around, I guess talking about get around things, only way for an insurance company to get around this result is to just lay down every time and say, insured, I guess that's what you say it costs to fix your house. I guess I'll just pay it because if I go through this contracted for appraisal process, then I'm inevitably going to lose. Not at all. The insurance.
I guess you could win, and then it could be less. But
I'm sorry to interrupt. I'm very excited to answer this question. Not at all. The insurance company it isn't as if appraisal is only available once a suit is filed. The insurance company, as soon as they're aware that there's a dispute that they don't intend to resolve by paying benefits,
you're right.
They can invoke appraisal immediately.
That's the obvious other way.
And that's the whole point of rush to the courthouse, is whether they had the ability to exercise that right. There's
also the possibility that the appraisal award itself could end up, the appraisers could say, yeah, you know what, they're fully paid.
Absolutely. And then if you're silly enough to file a lawsuit, then the insurance company absolutely wins because you have an appraisal that was conducted pursuant to the policy saying you don't get any more funds. And that's the whole point.
Maybe Mr. Hall could come up with a better sob story when he has his rebuttal. So I'm sorry, Mr. Hall, I didn't do very well for you. You have to take up the mantle for me.
Okay, so that is plaintiff's point, and that this was something that needed to be resolved prior to the final judgment being entered, there was no basis for plaintiff to pursue a request for fees once the insurance company got judgment in its favor for paying an appraisal award. And so this PFS was not made in good faith. It was there was no clear-eyed assessment of what its real exposure could be. This was a shot in the dark that ended up coming to fruition because the insurance company was able to convince the court that the appropriate way of dealing with this confession of judgment issue was through a post-judgment 1.525 motion, which, as I think I said before, is certainly the cart before the horse. So for those reasons, at least with respect to the denial of fees pursuant to the proposal for settlement, Synergy Contracting would ask that this court affirm the trial court's order.
All right. Mr. Hall.
Yes, thank you, Your Honor. Just a couple of points to make on rebuttal here. And so there's been this repeated reference to, I guess, in opposition to my statement that, 5 months went by with no record activity, another 5 months went by with no record activity. There's been this statement that, discovery was being sought. We'd asked for depositions and we had outstanding discovery. That's untrue. And the record is devoid of any suggestion that there was any follow-up or any communication or any motion filed, any letter that asked for any outstanding discovery once the appraisal process had concluded. And so that's just simply not the case, that there was some ongoing effort from Synergy's side to move the case forward. In fact, it was exactly the opposite.
I'm interested in your argument for the importance of the delay, though. If I or we or a majority of us conclude that the trial court got it wrong in entering judgment in favor of the insurance company, the rationale is, well, it's okay though, because the insured should have moved for entry of judgment in its favor, filed summary judgment based on confession and judgment, and it didn't. So I guess we'll just affirm. Is that your argument?
Well, I think that would work a fundamental unfairness against the insurance company, because Synergy has appealed the wrong thing then. Instead of filing a 1.525 motion within the time limit set after the judgment was entered, which was the entire purpose of getting
my point is this: is you're saying, well, there's this big delay. Why, they should have filed a motion for summary judgment on the issue of confession and judgment or something, but they didn't. So the court just, so we did it first. We got our incorrect ruling first, and therefore the appellate court should affirm, because the insured should have filed it. I don't really understand the importance of this delay. This delay of not filing something, in the plaintiff not filing something.
Because how is this case ever going to end?
Okay, that's fine. But what am I supposed to do? Affirm an incorrect judgment?
It's not an incorrect judgment. That's my position.
Well, why is it incorrect? Because the plaintiff didn't move with alacrity for summary judgment on the confession of judgment issue.
Because the plaintiff needs to follow the rules of civil procedure, and the court and the client and society is entitled to lawsuits being extinguished and resolved within some reasonable amount of time. And if FedNat sat on its agreed order of partial summary judgment, 5 months go by, nothing happens. If it sits with that, that's not a final judgment that brings anything to conclusion. And so if plaintiff never files its fee motion and FedNat sits with its agreed order that says you pay the appraisal award in full, the only way that this case is ever going to be resolved is through, I guess, the lack of prosecution channels 10 months later or a year later, whenever that happens. That's not what FedNat should be burdened with. That's not what the lawyer should be burdened with.
Help me out. I hear you're making this argument, and it's hard for me to accept it on its face that the insurance company is being burdened because it's not having to pay fees for a year.
Fees increase, Your Honor, and I think that one of the
so that's what this is really about, is you all want to be able to curtail their ability to take discovery and to generate fees, but then doesn't that just go into the reasonableness silo? In other words, that's what you pitch to the judge after the judgment is entered or while the motion is being heard, whenever it is. As to what a reasonable amount of fees are, and you put in there, look, they sat on this for 8 months. They churned the file. I mean, that's in fee hearings every day. Why isn't it just everything that you're saying about why the order is substantively reversible seems to me more along the line of, no, it's that the denial of the fees may have been proper. Perhaps we got to discuss this later. Perhaps the entry of judgment in favor of the insurer was an error, but all of the things that you're bringing to fore as to why no, we should have a judgment in our favor seem to me to be things that would be argued about the reasonableness of the fees.
Absolutely. About the reasonableness of the amount of the fees, but that's after an entitlement ruling is made. And that's what
But you're cross-pollinating. You're mixing and matching. You're using argument. You just did it. I mean, you're trying to use arguments about, hey, there's this big delay. And when you're asked the question, well, what does that do to the insurance company? What does the insurance company? Well, because they're generating fees. Okay, but that has nothing to do with what the substantive correctness of the judgment. What that has to do with is the reasonableness of the fees. Could you concede that?
Well, I'm suggesting that the significance of the delay is the reason for why the mechanism of the final judgment was sought, to put a bright line deadline on the end of the case. That's why the final judgment was sought.
But your motives don't matter. And I guess that's kind of what I'm struggling. Like the motive of why you did this, whether it is to get finality for society's interest in the finality of lawsuits, or whether it is in order to get the insurance company into a better posture when the inevitable fee entitlement issue comes to bear, doesn't matter. Either the judgment is correct or it isn't. Either the fee order is correct or it isn't. Right?
Agreed, Your Honor. And I think it was correct.
Okay.
And that's all I'll say, Judge. I don't want to belabor the point any, but I thank you for your time this morning.
Thank you both. At this point, that concludes both of those cases. We still have one more on the docket, but we're going to take a 15-minute